Good morning, everyone. This is the Senate Education Committee hearing, and we are starting off with Senate Bill 381, and Senator Reagan will present it.
Good morning, Madam Chairman and members, as few of you as there are in Senate Education. I bring before you today Senate Bill 381, and I'm Senator John Reagan from Senate District 17. So, this past year, the House successfully passed House Bill 581 that shifted the burden of proof in IEP proceedings from the parent to the school district. And I was assigned to the study committee that was also part of that bill. So when I presented myself at the hearing room, I was asked to chair the proceedings, which I consented to do. And we took testimony from dozens of parents who were unhappy people that they'd been unable to obtain services that legally they were entitled to through the efforts of the school districts who didn't want to perform financially to accomplish what they were being asked to do. So after 2 hearings, it was apparent there was going to be nobody in favor of the current system, and for very good reasons, that the practice was for the school districts to retain legal services and to pressure the parents until the usual result was the parents gave up trying to get the services for their special needs and disabled children. So I also chair the Performance Audit Oversight Committee, so we asked that group, which is part of the Office of the Legislative Budget Assistant, to prepare a performance audit of the special education system in the state. And I'm happy to report that that office is in the process of developing the scope statement for that audit. And it promises to be a pretty extensive audit. So, but our task here today is to introduce Senate Bill 381 and answer any concerns you might have about it. And the bill establishes an Office of the Advocate for Special Education. This is designed to be an independent agency attached probably through the Department of Administrative Services, and their task will be, or the advocate's task will be, to find out the state of services available to the children and the parents of the special needs children. So with that, I'll be happy to answer any questions.
Thank you, Senator Reagan. Any questions from the committee members? Senator Hennessy.
Thank you, Madam Chair. Thank you, Senator Reagan, for bringing this important legislation forward. Can I ask you, did you consider putting this under the child advocate's purview?
I was contacted by the child advocate and was asked, would I consider including this in their duties they're charged with. But in the dozens of testimonies from the concerned parents, I never heard a mention of the child advocate offering to assist them. I heard from the child advocate who thought this would be a good idea, but my reply was, where have you been? And why haven't you done anything to demonstrate any interest or provide any level of assistance to any parent?
Thank you.
Any other questions from the committee members? Senator Khan.
Thank you. Senator, thanks for introducing this. I think you're raising, a legitimate concern. I trust the study that you did. On the performance audit with you, your request was overwhelmingly received positively by the group. So the timing on that audit, do we know when that's likely to occur?
I expect we might see the scope in March. It will impact future legislation concerning the IEP process. And it may be of assistance in the House when the House has the bill as to what they might want to do. But it won't happen. It won't happen in February. So they're in the interview process now to establish
The scope.
the scope.
Got it. And the functions that are, if I can continue, Madam Chair, the functions that are listed in the bill, they look pretty extensive, and I was wondering, did you use the child advocate charge as a model for developing this? I'm curious how the charge was
It
developed.
came up in one conversation about where would this sit, and then we said, well, that's what they did with the child advocate, but no.
It's a lot to do, is what I'm
It's a lot,
observing.
it's gonna take a very ambitious, energetic person to pursue this list of duties.
Thank you.
Thank you very much, Senator Reagan. I had the same question as Senator Hennessy, so I won't ask it again. Having attended the hearings last year on 581, it became very obvious that parents really needed somebody who spoke for them. So I'm very happy to see this bill here now. Thank you very much. Senator Khan, did you want to?
No.
Oh, okay. Thank you very much, Senator Reagan. Jane Bergeron.
Good morning, everyone. My name is Jane Bergeron. I'm the Executive Director for the New Hampshire Association of Special Education Administrators, and I'm here representing over 270 members of our association. So the New Hampshire Association is pleased to share with you some testimony for consideration. At this point, we're not in favor or in opposition of the bill and would like to bring forward some comments and feedback for your consideration. From our lens, currently the New Hampshire Department of Education has a process for investigating special education complaints and the oversight of special education in all of our school districts. And there is no real evidence that that process is significantly flawed or inadequate. Additionally, the IDEA makes the state agency responsible for ensuring that all IDEA requirements are met, and therefore the IDEA is built on the assumption that the SEA is going to enforce all special education rules and regulations. From our lens, currently the New Hampshire Department of Education Bureau of Special Education Support lacks resources. Currently, only one position in the Bureau is funded fully by the state. All other positions are federally funded. Therefore, our association would ask, why not put the resources that are noted in SB 381 towards the Department of Education, the Bureau of Special Education, to make sure that they can do the work that they need to do. We also raised questions around FERPA, and that FERPA is as you all know, the Family Education Rights and Privacy Act. We had questions in terms of FERPA as it applies to educational agencies that receive funds from the U.S. Department of Education. And we would question as to whether or not an independent office of special education advocate would be able to fall under that category. We also raised questions about the bill and the definition of students with disabilities, in that left undefined as the bill is now, it really opens it up to 504 students and really significantly increases the expectation. The other, we listed several other questions which are in my testimony. The proposed bill directs the advocate to establish a minimum measures to ensure that copies of all documents which are to be discussed at a family meeting involving the student and the services. As such, we would raise a few questions around that. The first one is, what is a family meeting? And is that limited to or referring to an IEP meeting? The New Hampshire Special Education rules already require that an evaluation report is discussed at a meeting, and it must be disclosed with the parents at least 5 days in advance. This new statute would require that any document discussed at a meeting would need to be disclosed at least 5 days in advance, and does not allow the parent to waive that right. It's really not practical. Let's see, in terms of, we had a few other questions in here that I won't go into all of them. Also, as written, the advocate has the authority to investigate not only allegations of retaliation by the school district or school personnel, but also any and all complaints filed by a parent, guardian, or caretaker of child. Again, we list some questions for your consideration. What kinds of complaints can be filed? The statute creates no mechanism to ensure that such investigations are accurate or fair. The statute as written does not authorize rulemaking to ensure that such investigations are accurate or fair. The statute doesn't require that the advocate or the advocate's employees have any expertise in special education law, or conducting investigations. A few other questions that we had: the provision is written, it assumes that the retaliatory act to be investigated actually occurred. A more reasonable statute would authorize investigation of alleged retaliatory acts. There's a few more questions that we would raise at your convenience. You can take a look at them. The statute as written contains no limitations of statute of limitations. We were concerned about that, and in summary, we feel that the bill creates really a needless process. It duplicates what the Department of Ed is already required to do. And on behalf of our members, those are some of the concerns and feedback that we wanted to provide to the bill. We recognize and value the support and engagement of parents and families in the special ed process, as well as the work that the Department of Ed does in working and monitoring school districts. Thank you very much for the opportunity to present this information to you.
Thank you very much, and some of these points are in the letter that you have sent.
Yes.
Yes, thank you very much.
You're
Senator
welcome.
Hennessy?
Thank you. Thank you for your testimony today. Can you tell me who New Hampshire Association of Special Education Administrators, who your members are? Are they the special education teachers in New Hampshire?
They are the leaders of special education, so mostly school administrators, special ed administrators. We have some building coordinators. We have some school psychologists, people who have leadership roles in our public schools as well as our private special education schools.
Follow up. Follow up. Does every school have a special education administrator?
Not every school. Every SAU has a special ed administrator. They may have a different title. They may be a student services director. They may be an assistant superintendent for special education services.
Thank you.
But there is usually one person who oversees those kinds of things.
Anybody else? Any members? Questions?
Thanks, if I could.
Yes, Senator Khan.
Thank you for being with us,
You're welcome.
Ms. Bergeron. So I'm taking that, a couple of things. We've got a new law, a new procedure. How much do you think that is influencing, that the reason that we've got the new statute and the kind of testimony that was received by the study committee, do we have two competing kinds of things that just in sense of time, we've changed the rules in the game? And does that influence the outcome, or we just don't know? And so are we
And I don't know if maybe
needing to let something work its way through in advance of creating the separate function?
I think that's a very good point, in that with this new law around the burden of proof, it has just been enacted in July, to be able to give it some time to see whether or not it's having an impact. Our association checks in regularly with the Bureau of Special Education around parent complaints, concerns. Is there anything that we could be doing differently? So we try to make those connections, and I would imagine the department could share with you whether or not they have seen any data relative to comparing last year's complaints, hearings, as a result of the burden of proof law.
I think so. I assume we're going to hear from the department.
Thank you very much.
Thank you.
Next is, Maura O'Neill.
Good morning. Madam Chair Ward, Vice Chair Hennessy, and esteemed members of the Senate Education Committee, for the record, my name is Moira O'Neill. I'm the Child Advocate for the state of New Hampshire. The Office of the Child Advocate is an independent agency that's mandated to provide oversight of state and state-arranged services to children and to promote children's best interest. I appreciate the opportunity to speak today on Senate Bill 381 FNA, which establishes an Office of the Advocate for Special Education. We support this concept of investing in a resource for special education. However, we propose an amendment to limit costs to the state and to avoid creating a duplication of mandates with the Office of the Child Advocate. This bill, as you've heard, would establish an Office of the Advocate for Special Education, an independent agency. Our office is grateful to Senator Reagan and the bill's co-sponsors for recognizing the needs of many children and families that are not consistently being addressed by school districts as they should. Special education is routinely a cause for dissension in the contemplation of municipal budgets, as you know. That may be an influence on schools not aggressively meeting special education mandates. The Office of the Child Advocate has observed among the approximately 300 children who are in institutional settings every year under the custody of Division for Children, Youth, and Families, or held at the Sununu Youth Services Center, many of whom are shortchanged with unmet special education needs. Too often, the very manifestation of a child's special education qualifying disability has not been properly assessed or addressed, is the cause for the behavior that prompts out-of-home placements or adjudication for delinquency. Enhancing resources to assist children to access special education services is in the children's best interest for optimal development. It's also in the state's interest to reduce substantial funds on children receiving expensive deep-end services such as institutional care. So to best meet children's needs, we recommend that SB 381 be amended to place the special education advocate in the independent office of the child advocate. The primary reason for this is that the Office of the Child Advocate, under RSA 21V, already has jurisdiction over special education services. We may and we do receive complaints about special education. Senator Reagan points out correctly, and a recent community focus groups and interviews that have confirmed that as part of our strategic planning to do better in outreach to families. The office as a resource for special education concerns is, in fact, not well known. This shortcoming is viewed as an effect in limiting staffing for community outreach and also its very new expansion of the jurisdiction of the office. We also lack the resident expertise in special education law that would be most helpful to children with complex needs. So while thus far we've been able to refer cases to others in the state with special education expertise, those resources are also fairly limited. Placing the special education advocate in the Office of the Child Advocate would bring that expertise and extra manpower to provide outreach to families and effectively advocate to meet their needs. It would also be less confusing for families to have one door leading to assistance navigating systems and advocating for their children. Many children with complex special education needs have other needs served by multiple systems, such as developmental disabilities, behavioral health services, as well as juvenile justice and child protective services. To that end, the Office of the Child Advocate is already working with many of the same families that would benefit from a special education advocate. Creating one door for child and family assistance in the Office of the Child Advocate would serve families well and situate the special education advocate with in-house supports and expertise in these other specialty areas. Placing a special education advocate in the Office of the Child Advocate would save the state considerable funds. For your information, I've provided just a very basic overhead cost for the Office of the Child Advocate that represents potential savings of approximately $26,000 for the very baseline. This doesn't include the cost of an administrative support position for the Office of Operations or additional legal counsel. And I'm sorry to say, as an example of why you would need additional legal counsel, the Associate Child Advocate, who is also the office's legal counsel, spends enormous amounts of time responding to right-to-know requests, even despite the Office of the Child Advocate being generally exempt. I would imagine that the special education advocate would encounter those requests as well, for which in-house counsel would be necessary. Consolidating that resource alone would preserve significant time for the special education advocate to attend to the mandate of assisting children and families with accessing special education services. So the Office of the Child Advocate is just 4 years old. In a short time, it's established itself as a valuable resource to children and families in many domains of children's services. Recognizing the need to follow the field towards more prevention services to minimize child protection and juvenile justice cases, the office's jurisdiction was expanded to all children's services that went into effect in September of 2020. So this expansion of services is just over a year old, and we're still assessing the workload and staffing needs. It's very timely that Senator Reagan brought this bill forward, as the need for this specialized resource is recognized in the Office of the Child Advocate. For these reasons, I would urge that you amend 381 and place special education advocate in the office of the child advocate with an allocation of funds only for a position and one legal aid to support the advocate. And I'm happy to take your questions if you have them. Thank you for your time.
Thank you very much. Any questions from the committee members? Senator Khan?
Thank you, Madam Chair. Thank you, Maura. I have learned of your work over the last few years, and I'm very impressed with what you do. Thanks. I want to understand what the capacity of your office is currently. So what is the annual budget and staffing?
Thank you for the question, Senator Khan, and thank you for the kind words. I think our budget is now, and I'm not the numbers person in the office, but I think our budget is around $750,000 at this point. We have a staff of 6.5, and we will be 6.5 coming in July. There's another position coming, an ombudsman type position. We received 2 new positions after our jurisdiction was expanded. So originally, you may recall, the Office of the Child Advocate was established to oversee DCYF, which was Juvenile Justice and Child Protective Services. As we saw the focus on preventative services, it became clear that we had to expand. And as I mentioned here, providing resources for families who have concerns in accessing special education services is truly an opportunity to prevent involvement in child protection and juvenile justice, because a lot of children who are suspended from school because of manifestations of their disability that's not being treated in a proper individual education plan may end up being involved in delinquent acts. So it really does fit, and the jurisdiction is there. We do have some expertise. I've worked in the past on individual education plans. We have an early childhood education specialist in the office, but not really true legal expertise around special ed. So we have partnered with legal services and other experts around the state when we've come across more complicated cases. But even they are overloaded and it takes time. So it would really, we're in the middle of developing a strategic plan right now, and building resources around special education was already on the docket. So it just sort of fits, and the timeliness is very good.
If I could continue, the budget that was suggested is a $500,000 transitional dollar amount. And I see this, I think I interpret your table here, basic costs associated with the overhead, as a savings that you could envision were the function added in to the child advocate. Does that mean that there's a $475,000 add to your budget to pick up this work?
Thank you for the opportunity to clarify that. I was just, the numbers that I have here, the $26,000 are just basic overhead fees. So an independent agency that's attached to the Department of Administrative Services still has to pay rent. You know, it's getting more and more costly to just be a standalone agency. The cost of placing the special ed advocate in the Office of the Child Advocate would really be just the cost of salary for that individual person. And also we're recommending a legal aid to assist that person. And I'm sorry, I don't have the salary amounts estimated for that. I can get that for you. My staff who does that is out this week. But my estimate would be that it would be less than half of the allocation that's been proposed. And this is a really important point, because there are so many limited resources for children in this state right now. And so spending money on overhead for a standalone agency seems somewhat wasteful when there's already an agency that has a mandate to do that job. So it's a really good opportunity to recognize the need and to bring over an expert and strengthen the Office of the Child Advocate, but to do it with the least cost possible.
If I last point, I think it would be helpful to see what your fleshed out plan would be. My guess is we're going to have 3 proposals on this, something that comes from the department, something that comes from you, something that's proposed as a separate office in this legislation. So I think understanding what you would envision, what the department envisions, would be helpful to put alongside what Senator Reagan envisions.
Sure, Senator, thank you for that opportunity.
Thank you very much.
Thank you.
The next person who wants to testify is Marilyn Muller.
Good morning.
Morning, welcome.
Thank you. Thank you for this opportunity to speak and share my story. My name is Marilyn. I'm a resident of Exeter, and I'm a mom of a previously functionally illiterate child. She is a victim of multiple injustices that are the result of government systems failures, beginning with the poor quality teacher training and credentialing programs in our taxpayer-funded public university system. Public teaching colleges fail to ensure teachers are provided with the knowledge from our taxpayer-funded research that specifically tells us how the brain learns how to read. It fails to provide them with the skills to ensure our educators meet federal mandates within the Every Student Succeeds Act, the Individuals with Disabilities Education Act, and other education laws that should be implemented over 13 years of compulsory education. Therefore, most teachers graduate college with worthless degrees, including those that have masters in curriculum and instruction. These worthless degrees set our teachers up for failure in their chosen profession and for malpractice in America's public schools. These failures are further exacerbated by poor quality balanced literacy curriculum and harmful instruction in our general education classrooms. I'm here today to support SB 381 under the presumption that the independent Office of Special Education Advocate will be independent and will help New Hampshire families access services to ensure their IDEA eligible student receives the free appropriate public education that federal laws are supposed to guarantee, and that this newly created position is not exploited as a job for individuals in return for political favors. In the winter of 2015, my family was forced to secure a private neuropsychological evaluation for our daughter through Massachusetts General Hospital's Learning and Emotional Assessment Program. We incurred personal expenses of $3,500 to identify why our above average intelligence daughter unexpectedly struggled to learn how to read, write, spell, and numerate because our A-rated district did not comply with the federal child fine mandate by continuously denying our requests for special education services evaluation throughout kindergarten, first grade, and second grade. We were repeatedly reassured by the district that our daughter was fine and not to worry, she'll catch up. My traumatic experiences give me reasons to believe that there is an unquantifiable number of children in New Hampshire with invisible learning disabilities, like my daughter's, that are needlessly struggling in general education classrooms because districts may not be compliant with the federal child fine mandate in the Individuals with Disabilities Education Act due to a lack of enforced compliance. Additionally, after we secured an individualized education program, which is an IEP, we made numerous good faith attempts to collaborate with her IEP team throughout second grade and third grade. She showed signs of further deterioration while receiving special education services. And to quote the Wharton Professor of English at the University of Oxford, Professor John Bailey, children's behavior is inextricably linked to their level of reading. With that knowledge, we were forced to make the difficult and not free choice to unilaterally place our child in a private special education school that is able to give her what she most needs to thrive and be proficiently literate. Each week, I have the luxury of driving my IDEA eligible child 700 miles to a private special education school that we have self-funded the last 5 years at a personal expense of $263,400. That's tuition only. This is because most districts dismiss independent education evaluations as opinion and or hearsay. They do not consider parental input in the IEP decision-making process in good faith. They make unilateral special education services offers on a take it or take us to due process basis, resulting from the fact that districts did not bear the burden of proof prior to HB 581, coupled with the fact there is no enforced compliance with the federal IDEA because New Hampshire school districts self-report compliance. The New Hampshire DOE, and most have never undergone a forensic audit of federal funding. Therefore, I'm left wondering and worrying about how many thousands of New Hampshire families have a child or multiple children with special learning needs, most of which have a specific learning disability, like my daughter's, which is dyslexia, dyscalculia, dysgraphia, okay? Most children's needs can be served in the general education classroom if we properly trained our teachers. Yes. So to continue, these families would benefit from an independent, again, I say and stress independent, Office of Special Education Advocate outside of the New Hampshire Department of Education by enacting SB 381. The scope of services that must be provided some children under federal Medicaid law is broader than what is required under IDEA's definition of, quote, related services. As such, many parents of children with IEPs and 504 plans are coerced by districts into signing irrevocable release forms to bill Medicaid, even though schools can't possibly know who's Medicaid eligible, or can they? Furthermore, I have reasons to believe that the prior absence of districts' burden of proof explains why most parents lose due process and why the few parents that settle in mediation or have a favorable due process outcome have been silenced until death with taxpayer-funded non-disclosure agreements, which are in direct violation of New Hampshire's right to know statute, and they still can't access their child's rights to services. In truth, free, appropriate, public-funded education sits on a deserted island inside an iron triangle that's protected by local school boards, state DOEs, the federal DOE, and teachers' unions. There is no access to services, and the outcomes of students with disabilities show this in the single-digit proficiency scores of students with IEPs that were recently published by the New Hampshire DOE. To quote a PhD in economics, Byron Schlobeck, quote, parents sitting outside education's iron triangle who actually figure things out are ignored, or they're discredited with outright lies, like the lie that testing and its problems were all the fault of legislators and no child left behind, end quote. Today, I'm wearing a hat emblazoned with the letters USA. and our nation's flag. Because I was raised to be a patriotic American, one that stands up for truth, liberty, and justice for all. So many brave Americans have sacrificed their lives to protect our freedoms. I believe it is my duty to protect our nation's innocent children and their rights to free, appropriate public education and literacy proficiency. Because literacy is equity, and you all know this. New Hampshire's poor quality special education services and probable noncompliance with the Federal Individuals with Disabilities Education Act is a K-12 education equity and social justice issue. In fact, I believe it's a crisis. It's one that mandates HB 581 and SB 381 until statewide reading proficiency scores reach 100%, because that is attainable. This can be easily achieved by investing our federal, ARPA, and ESSER 3 taxpayer dollars, our state and local taxpayer dollars, in credentialing each general and special education teacher in the science of reading and direct explicit instruction to ensure fidelity of instruction in each general and special education classroom. I'm happy to volunteer my time and my knowledge to guide the state and the district through the aforementioned process. I'm asking you to support SB 381 so that parents will hopefully have an independent ally to help them access their child's rights to free, appropriate public education and literacy. In closing, to quote a former illiterate slave and one of my personal heroes, Frederick Douglass, it's easier to build strong children than repair broken men. Thank you.
Thank you very much. Any questions from the committee members? Senator Khan.
Thank you, Madam Chair. Thanks for your testimony and story, and very moving, and I appreciate that you've taken the time to share that. I'm curious what school district your child worked with.
I prefer not to say. Parents are retaliated against frequently.
Okay. Thank you. Clearly, I'm trying to understand, and I'm fine with your answer. I'm just trying to understand.
I've been to court to get orders of protection against people that have threatened me over my experience.
Thank you.
Mm-hmm.
Any other questions? Thank you very much.
Thank you.
I just have a question for clarification here. Bonnie Dunham has checked off both support and oppose, and I just want to be sure I have the right thing. You can just clarify that. You did not want to speak, but if you want to just clarify that.
Sure. I did need to speak. I just didn't check it off. Is it okay? Very quickly. Okay.
I didn't hear a question.
Oh, I didn't check it off, but I meant to.
Okay, so are you supporting or opposing it?
I support the intent, however, I think it needs some work. As it is, I don't think it's possible for one person to do all of that. It's somewhat duplicative, and there are areas that could be improved. For example, the meeting surveys go back to the school. As you just heard, sometimes parents are afraid to provide that information, but if it went back to the office of the advocate or ombudsman, they could then collect all of that data and find out what are the issues that are going on in school districts that are impeding parent involvement. And there's lots of room for collaboration with other organizations and to find out what are some systemic issues that could then be repaired as well.
Madam Chair.
Okay, so you would,
If this
Miss, do you plan to testify? And if so, could you just state your name for the record?
I'm sorry, Bonnie Dunham, Dunham, as a private citizen, parent.
Thank you very
Of
much
an
for the
old child.
clarification. Metzner? No, was Krista or
Christine.
Christine Metzner? Welcome.
Good morning, Senators. My name is Christine Metzner, and I live in Rye, New Hampshire. I'm here to support SB 381 FNA. And my experience with my son's 504 plan and in the IEP process demonstrates the need for a special education advocate here in New Hampshire. I brought this 3-inch binder with me. It's overflowing with emails, letters, plans, notices, meeting notes, meeting corrections, doctor's letters, updated doctor's letters. I could go on, just to give you a reference as to what happened in just 1 year of this experience. And the reason that this lasted a year, only a year, is because I got so tired of it, we decided to homeschool my son. At the age of 10, my son developed a neuroimmune condition. He had a lot of neuropsychiatric symptoms, extreme anxiety, agoraphobia, sensory issues, and cognitive regression. It was like he had a traumatic brain injury, but his symptoms waxed and waned and progressively got worse. So when he was in 6th grade, we developed a 504 plan and later wound up in the IEP process. I'm a lawyer by training. I haven't practiced in a while, but I read the laws. It took me hours to begin to understand the framework of the system, especially the IEP process. Even for me, an attorney, it was overwhelming. I turned first to an advocate and later hired a lawyer to help. Before I hired the lawyer, I made it clear to the school what I believed would help my son. Some home tutoring because his agoraphobia was so bad that he was unable to leave the house. We had at least 2 meetings at the school that my son's psychologist attended to explain his condition and his needs, but they wouldn't say yes or no to my request. Once I hired a lawyer, the school started having its lawyer attend the meetings. With 2 lawyers in the room, my simple request for a home tutor a couple hours a week was magically granted. But this was 4 weeks and 3 meetings after my first request. The tutors came for about 2 months until the end of that school year. I estimate that my son had about 20 hours of home tutoring. That was the entirety of his public education in the last 6 months of that school year. And I know that once the 504 and IEP processes were concluded, the lawyers made more money than the tutors, not to mention the hours of administrator and teacher times at meetings where there were as many as 10 to 13 people in the room, all for furnishing a few hours of tutoring a week. The summer went by, and in September, the school would not allow any further tutoring despite the recommendations of my son's providers. Instead, my son was on a very part-time schedule. He was improving medically, and there was a plan to gradually increase his time at school. And as to the IEP process, we agreed to evaluations. But 60 days passed, and we didn't hear from the evaluators. We agreed to the school's request for an extension, but 30 days later, still no completed evaluations. And the school kept indicating that they needed these evaluations to see if they should continue tutoring at home. After 90 days, I never heard from one of the school's evaluators, and the school's chosen psychiatrist never contacted my son's providers for the information he needed. So at this point, there was a total of 9 504 and IEP meetings. My son's psychologist was at 6 of these meetings at my expense, and my lawyer and the school's lawyer were at 5 of them. After all that, we finally decided to homeschool our son. They weren't listening to my input. They weren't listening to my son's provider's input. We provided multiple doctor letters. But he was not getting free and appropriate education. And the school, it felt like the school was kicking the can down the road. And what he needed to succeed and make progress in education did not seem to be their concern. While homeschooling my son, I was shocked to learn how many people are homeschooling their children because of the difficulties they faced with securing appropriate 504s or IEPs. Everything with the schools was struggle, and parents of children who need accommodations or services need an independent state government office to turn to for help. They proudly give procedural safeguards at every meeting, but they're not written in plain English. Even with a law degree, I had trouble understanding them. If I needed help to the point of hiring an advocate or lawyer, imagine a single mother with a full-time job and children with significant educational needs, or someone for whom English is a second language. Finally, schools are spending more and more on legal fees. My own SAU is talking about increasing expenses for legal fees because they see a trend of advocate outreach by parents. Parents are reaching out to advocates because the schools are so difficult. And with all the training and support that school personnel, including special administration directors, and I should say especially special education directors, they receive so much training and support from the district's law firms at their state associations. There should be no reason for them to hire lawyers for individual 504s and IEPs. Instead of lawyering up, the school should be asking why so many people are asking for help. The reason is parents don't fully understand the process, they don't feel heard, and they're quite likely overwhelmed by the process and parenting in the 21st century. I noted some things that some of the previous participants stated. And there was an indication that perhaps this should be just limited to IEPs, but I think it's a very good idea to include 504 in this office because there's so much overlap between IEPs and 504s. And sometimes schools will try to push parent to a less expensive 504 plan. And also, I agree with Bonnie Dunham's suggestion that it might not be a good idea to expect parents to provide evaluations after each meeting and provide them to the school because parents do truly fear retaliation. I'd like you to know that after I homeschooled my son for most of 7th and all of 8th grade, his condition improved, and he returned to public school for 9th grade, and he's thriving as a sophomore. I don't need to be here. I don't have a child with a 504 or IEP, but this experience was so traumatic, I really felt compelled to come here and share my story. Thank you.
Thank you very much. I have to commend you on taking charge and homeschooling your child.
It was actually very enjoyable.
Good. Any questions from the committee members? I don't see one. Thank you very much.
Thank you very much.
Patricia Eno? Okay. Patricia Eno? Welcome, Patricia. I have to ask at this point, because we've been going for quite some time, if you have a written testimony, could you just sort of summarize it? Other than that, go ahead.
Thank you. And I want to thank New Hampshire, the sponsor, Senator John Reagan, and I'm speaking in support of Senate Bill 381 to establish an office of the advocate for special education outside of the New Hampshire DOE. And I feel that's necessary, that although the DOE does have the responsibility to do certain things, I feel that responsibility is not being met to allow us to do certain things. For instance, the parent has a right to compel witnesses to appear at a due process hearing for free. It's not my job to make that happen. That's your job to make that happen. I shouldn't have to figure out any kind of a summons process, hire process servers, my witnesses, if the hearing officer agrees that they're necessary, they should appear at no cost to me and at no undue burden to me. The instructions in the informal guide to the New Hampshire Special Education Due Process Hearing contain certain words to the wise. As you know, these disputes can be very emotional. Parties may be tempted to yell, to call others names, to pound the table, to accuse people of unprofessional conduct or other uncivil behavior. The first half of that is disrespectful. The second half is just poor legal advice. If somebody has had unprofessional conduct and it's getting in the way of a student's fate, the due process hearing is precisely the venue to bring that up and advocate to the student. Here's what the guides should say. IDEA is enforced by these New Hampshire laws. It should say either the district or the parent or eligible student can request any alternative dispute resolution method directly. There are deadlines to keep in mind, and asking the district to handle the request allows them to just kick it down the road. Here are the instructions to do that. Whatever dispute resolution you would like to participate in. The school has a right to say no, and that should be part of the record because you have the right to make the hearing public. Here's how to make the hearing public, the due process hearing. At the hearing, the local educational agency should be responsible for educating your child, should observe all the accommodations listed in your child's IEP. There shouldn't be a separate process to allow your child to appear. You shouldn't be advised not to bring your child because we don't have anywhere for them. We don't have any accommodations for them to be at a due process hearing and advocate for themselves. They're allowed to be part of this process, especially if they're an older child. The written decision, as well as the due process guides, should provide technical information on how to appeal the decision. I'm talking about a name and an address and a phone number of the court, not a court of competent jurisdiction. Go ahead and find it on your own. I'm a parent. I'm not a lawyer. I'm a citizen. I've got a U.S. high school diploma and a Bachelor of Science degree, but no background in New Hampshire civics. I'm not supposed to need one in order to help my son get a free and appropriate public education. I'm supposed to get the technical information to be able to present my case at a fair hearing. A fair hearing would not include a post-hearing submission of up to 50 pages arguing what New Hampshire laws are applicable to my case. Again, I am advocating in favor of Senate Bill 381. We need the Office of Advocate for Special Education because the New Hampshire DOE is not meeting its responsibility to give us the information we need to advocate for our kids. Thank you.
Thank you very much. Wait a minute. Are there any questions from any of the committee members? I guess Senator Khan has a question for you.
Thank you, Ms. Eno. I am curious, did you try to get assistance from the Department of Education?
Yes, yes, I did.
Yeah, what was that experience?
It was a nightmare. I spoke, of course, to the manager for special education due process hearings. I mentioned my difficulty with subpoenas. I was granted subpoenas. They came in a little envelope labeled copies of subpoenas. I didn't know that New Hampshire court system considered it my responsibility to have those served, because that would not be free, that would not be appropriate, and that's not something I as a parent know how to do. That would be hiring sheriffs in my case, a half a dozen different counties in 2 different states to serve those subpoenas. I went to due process with no witnesses. I tried to get my son there. I was told they didn't have Wi-Fi. So if my son happened to have a migraine, there would be a problem. There would be no safe. The guidelines say that there is no place for your child to wait that's comfortable outside of the hearing. There's no supervision. He didn't need supervision. He needed a place to study and Wi-Fi, comfortable place to sit where he could do his work. And that wasn't provided. Less than a year later, this was in May of 2019, no Wi-Fi at the site for New Hampshire due process hearings. Less than a year later, everybody's remote, everybody has Wi-Fi. Does that answer your question, Senator?
Yes, thank you.
Thank you. Anybody else?
Thank you very much.
Thank you.
Shannon Bouchard. Okay. I can take the next one. Let's take the next one. Welcome.
Hi, thank you. My name is Shannon Bouchard, and I wrote up a little something. I have to take my glasses off because I'm backwards. Parents of special education students are in desperate need of a special education advocate working on our behalf. If I had this advocate to help me to make sure that my district was following the laws and doing what is in the best interest of my child, then my 15-year-old daughter wouldn't be home receiving no education while I fight for an appropriate IEP for the last 2 years. I would have had help understanding and applying the Manifest Educational Hardship Award that she was granted due to bullying by the district school at a formal hearing. I have been bounced from one organization to another with little help. I am also disabled with multiple sclerosis and diagnosed over 20 years ago, and have brain lesions which make retaining and understanding information extremely difficult. I feel that I have a place I could go, if I had a place I could go, knowing that they too had my daughter's best interests at heart, that I could trust they were not lying to me, and would have been invaluable to me and other parents. The districts have a team of lawyers on their side who are specifically trained in special education law, and the special education coordinators and case managers are also trained in the laws. It would be invaluable to have a special education advocate for the parents, making sure our children's civil rights are not being taken advantage of, that all special needs children, no matter their parents' education or their financial ability, they would be protected by an impartial, separate from the district, and was protecting my daughter's rights for a free, appropriate public education. My daughter has had no education this year at all. She was unenrolled unilaterally from my district, from her placement, because I did not want her to be in a resource room, because that's where she was bullied by going into the resource room. So she wouldn't go to school if she had to be in a resource room. And they said that's the only way she could have an education is if she went to a separate classroom, which is not following the law. So because I did not agree with that, they unenrolled her, and she's been home ever since. I told them that I was going to enroll her in a private public academy and give the district the bill for that. And the case coordinator answered me that that is only done at a last resort. My daughter has had no education this entire year. I don't know what more of a last resort we could be at than this. That's all.
Thank you. Any questions from the committee members? Senator Hennessy.
Thank you, Madam Chair. Thank you for coming today to share your story. I would just recommend that you reach out to the Child Advocate's Office. She was here earlier testifying.
Yeah, I just gave her my email. I never, no matter if I called the New Hampshire DOE, I've called the disability rights, they couldn't help me. I called the parent information center, they never mentioned it. I've called everywhere for 2 years, wrote hundreds of emails to everyone I could think of, and nobody ever told me that there was anything like that.
Thank you, and good luck.
Thank you.
Any other questions from the committee? Thank you very much.
Thank you.
Russon Chester. Russon? Russon? R-U-S-S-A-N?
Russan. Russan Chester.
Russan.
Thank you.
Okay. Welcome.
Thank you. I also don't have a pony in this race directly. I have no children in the school system now, and I don't work with special needs children anymore. However, I used to. I worked for Child and Family Services, or DCYF, here in New Hampshire for over 15 years. And I'd never heard of the Office of the Child Advocate either. I understand they're 4 years old. I've been working with many parents that I know of that have special needs children, and tried to take it on myself to be to help them go through the process of getting an IEP in place and then making sure that the IEP is completed. We have never heard, and as recently as last week, I spoke with the Department of Education, and they never provided me with that information. I've spoken to the DRC, I've spoken to NAMI, I've spoken to school boards, administrators, special ed teachers, school counselors, and some of the largest mental health agencies in New Hampshire. And today was the first time that I'd ever heard of the Office of Child Advocate, and that's a travesty. The fact that we are paying for someone to help parents, and what Maura explained to me is what they've been doing is working closely with the Department of Education, educating them on what their role is. Obviously, you've already heard testimony that that doesn't seem to be working. Our Department of Education, unfortunately, is not meeting the needs of our students. It's not meeting the needs of our parents. Even the Office of Child Advocate admits that most of the time she is working with children that are already in an institutional setting. They clearly have a lot more resources than our parents in New Hampshire do. It's time for New Hampshire to stand up for our special needs children and stand up for our New Hampshire parents. And I hope that all of you support this bill, and I will take any questions.
Thank you very much. Any questions from the committee members? Seeing none, thank you. Maureen? Tracy? Welcome.
Thank you. It's okay to take this down, right, while I talk. Thank you for having me. My name's Maureen Tracy. I'm from Merrimack, New Hampshire. I am a former special education, regular education teacher. I also taught undergrad at Franklin Pierce University in the education department. I'm also a mom of a now young adult who has a disability.
I am in favor for this special education advocate, and as somebody had said, independent would be wonderful. Currently, I am an advocate, and I have kind of changed my position and now opened a business to be an advocate for special education, especially over the past 2 years. Myself and 2 other women who have children with disability have now entered law school, Massachusetts School of Law, due to the unfairness of the schools having attorneys, and we could not find attorneys for families here in New Hampshire. It is, over the past 2 years, I have seen a huge decrease in accountability and even any what's the word? Any following of the law. I feel at this time schools feel like there is really, I tell parents there is no IEP jail, there are no IEP fines, there is nothing, we can't take it to a complaint, and they might get a little slap on the hand, but what I am seeing is retaliation against the families for reaching out, making it harder and harder and harder for families to get what they need. My main advocacy is really around restraints and seclusion, which has gone up dramatically since the COVID has started, which would be understandable. Not only are students feeling more anxious, staff are feeling more anxious, as well as there's just a lot on everybody's plate. And kids who never even received any behavior issues before are now being restrained and secluded. Restraint and seclusion here in New Hampshire happens more than people think. There are padded rooms, if people don't know, inside of most school buildings. There's certain measurements that have to be there. And when a student starts to go into what we call fight or flight, which happens to all of us when we are feeling threatened, and unfortunately kids with emotional behavior disabilities feel threatened by things that may not be. And instead of the skills that the students need, the teachers need to de-escalate, they end up going into fight or flight, and there's this continual thing. As an educator at higher ed, I do know that this is not taught. It is not taught how to properly de-escalate a student. Also, as one of my older children was, while she was going to college, was a substitute and a paraeducator, and she was thrown in to places without helping kids with the most difficult disabilities, with no training, no IEP, no anything. Luckily, she grew up with a sibling who had a significant disability, and so naturally she knew how to do this. But I have seen this hands-on, and this is not to say that teachers are not trying hard, because they really are. It's the system. And myself as a teacher, I was pushed out of a school district years ago for complaining about putting a student into a seclusion room. This has been my passion, restraints and seclusion. I have seen over the past 2 years kids with bruises. I had one client who was restrained over 130 times in a school year. And we've gone to the DRC, we've gone to the Department of Ed, we've put in complaints, we have gone to the OCR. None of this gets really resolved. There's too much going on. And I would say that the child advocate, which is, I believe, for DCYF, which I have heard of, for DHHS, I don't believe would have the capacity to handle special ed and DHHS. I do believe that we do need an advocate who will, and also for, I would call whistleblowers. I know there are a lot of teachers who don't like some of the things that are going on, but they want to keep their jobs. I know this from past students just calling me saying, I don't think this is ethical, what do I do? And I have to tell students, you have to make the choice. Do you want to keep your job, or do you want to speak up? Because that's the reality of what happens in schools. And just to let you know, I have worked in schools for over 20 years, and I do see what happens inside of schools. So thank you. And any questions?
Thank you very much. Any questions from committee members? Senator Khan?
Thank you, Madam Chair. Do you ever serve as an advocate for families that are seeking special education hearings?
We're starting to do that right now, yep. We haven't done it in the past. Now, because of the change in who is the burden of proof, that's what we're going to start doing. I have been working to look at some pro bono attorneys who can come in and help with that, because it is a very cumbersome event to do. But we're now at that point with 2 of my families right now because of the severity of what's going on.
Thank you.
Mm-hmm.
I don't see any other questions. Thank you very much.
Mm-hmm. Thank you, Brenda.
That takes care of the people who signed up to speak. Anybody else who, Senator Reagan?
We had a phone call from Kate Shea asking to testify.
Senator, could you speak to the microphone, please? So that people on the screen can hear you.
So we had a request from a woman named Kate Shea, who's the parent of 3 of her 4 children have been victim of this very system that we're bringing to your attention today. So she thought she was about 3 more minutes out. So I don't know if we can.
She coming here in person to
Yes.
testify? Okay. Well, maybe what we could do is to hear from the Department of Education in the meantime. We have somebody from the DOE? Okay. A lot of issues to be explored.
Good morning. My name is Rebecca Fredette. I'm the State Director of Special Education. I don't have a prepared statement for you as I listed on the sheet. It was technical assistance, but I can give you some feedback about the bill if you would like.
That would be very helpful.
Great.
Because you've heard a lot of testimony, and it would be nice to have some of the issues and concerns addressed by the
Sure.
DOE.
So I did attend all of the hearings that Senator Reagan discussed over the summer, and we heard parent concerns. We heard the concerns that they expressed. We heard the things that were happening, and brought it back to the Bureau. And as we stated in that meeting, we have been looking at our monitoring system. We have been looking at the things that we do in the department to say, are we doing enough? Are we doing what we're supposed to? And have started to revamp that process. It has been slightly slowed with COVID. I will be honest. As I came on 2 years ago, we are still in the process of doing that, and we are still in the process of getting feedback. Some of the things we heard that we had not considered previously were providing more supports to parents. And although we have the Parent Information Center that is a federally funded organization here in the state, it was clear that we needed to provide some more supports to parents, and so we are in the process of looking at those pieces. If I look at the bill in its entirety, there are many things within the bill that we already are required to provide. So we are required to take the complaints. We are required to do monitoring. We do special monitoring when appropriate, and we provide technical assistance to districts and parents. We do complaint investigations, and then we do track all disagreements and complaints through Attorney Fenton's office. She tracks all of the due process hearings we have, all the special education complaints, and there is one person who is assigned to do just special education complaints. She takes all phone calls from parents regarding complaints. She provides assistance, and she provides the process for filing a complaint, and if she needs to, would refer them to Stephen Berwick, who also does the due process hearings. We do implement and track district achievement and success. We have 17 indicators that we report to the federal government, and they deal with least restrictive environment, IEP process, all of those pieces, and we do track those and are looking at the data for those pieces. And then we do establish minimum compliance measures for districts that they must meet. While we had a process that was very limited in how we monitored districts. In the past, the process was limited to 6 districts per year, and they were chosen based off of a risk rubric. In that, we found, when I started as the director 2 years ago, I found that we had only monitored a very small portion of districts. We have about 175 districts, and we had not monitored 122 of those districts in more than 5 years. So we realized that that was an issue, and we needed to change the way we monitored, and are in the process of doing those pieces. I think that I completely understand the concerns that parents have raised. I am a parent of a special ed child as well. I understand that the process is difficult. And I understand that they feel they need something more. And I would not be opposed to some pieces to this. My concern is the duplicative nature of some of the pieces that we would be doing the work that we are still required to do, and then we would be asking the Office of the Advocate to also do that work as well. So districts would be answering to 2 processes, whereas if we fine-tune our process more, I feel we could meet some of the needs that have been expressed here. One of the pieces that had been mentioned is the Office of the Advocate has worked with the Department of Education. They have not worked with the Bureau of Special Education Support. They may have worked with other people within the department, but we have not. I oversee all special education. They have not worked with my office directly. That is something that I can reach out and start to work with her and start to do those pieces. And then they had asked about special education in 504. There are different parameters regarding 504, so if that were something that were put into that, it is a different set of knowledge that needs to be known, as well as the IDEA process. If you have questions, I'm more than willing to answer any of them for you.
Questions from the committee members? Senator Hennessy.
Thank you, Madam Chair. Thank you, Director, for coming today. So just thinking back to some of the testimony that we heard today and looking at the bill here, and you mentioning that some of it would be duplicative between your department and what this new role would do. Looking at the example of a 15-year-old that hasn't been in school yet once this year, does your department ever say to the school district, you need to meet the education needs of the student, or do you say, here's the due process procedures?
No, so Natasha Lupiani is the person that takes our complaints, and typically when she gets a call from the districts, it depends on the situation, obviously, but she would talk with the parent. She typically reaches out to the district as well and says, this is what we've heard, this is what's going on in your, what's going on, tries to get both sides of the story, basically, and then would provide any resources as to, okay, this is what's happening, this is what needs to happen, or in many cases, she has said, you're supposed to be doing this. This parent has a legitimate concern. They can file a complaint. So she does reach out to them and ask them, and if need be, reaches out to me and says, I've reached out to this district. I'm not really getting anywhere. I haven't had to call anyone yet, but she does reach out to me.
Thank you.
Anybody else? Senator Khan.
Thank you, Madam Chair, and thank you, Ms. Fredette, for joining us. You must keep track of the number of due process hearings.
That is tracked through Attorney Fenton's office, yes.
And do we have a sense of the volume?
Whether it has increased or since there has been no increase from what I understand. I would have to clarify, she's not looking at me. But as I understand it, there has been no increase in due process, and there has been no increase in complaints since HB 581.
Okay, and 581 went into effect when?
In July.
It's probably a little early to know that,
Yep,
right?
it is, yep.
There's clearly a concern being brought that the hearing process is not concluding, and the cases are taking a long period of time to resolve. Does the office keep track of that information?
Again, I would, do you keep track of length? So she's saying that Attorney Fenton is saying she can provide the information to the committee. We don't have it on hand right now, but it is available, so we could provide it to the committee.
And I guess, you know, if I step, you know, what's the request? It's, what information, if we were to go forward with this, knowing our starting point, and are we getting any better, would be good information to know, right?
Sure.
So we've got 50 cases a year that go through due process. They generally resolve within 2 months. We've got another 20% that take longer, and understanding just where, you know, understanding those cases a little bit better.
Yep.
Maybe the task force had that information from the department. I don't know, but that would be helpful. If I could, one other tangent.
You all set?
No, I'd like to understand. It was described earlier. The resources in the Department for Special Education are very slim. You've just indicated, no, there are a couple. There's an intake person. There's a hearing person.
So I can describe the
thanks.
bureau to you. Sure. So in the Office of Governance, which is overseen by the commissioner, there is Natasha Lupiani, who takes the complaints for special education and takes all of the phone calls for special education. That is funded through our federal funds for IDEA. Stephen Berwick does all of our due process hearings. That is completely out of my purview, so I would defer any questions on that regarding to Attorney Fenton. In my bureau, we have one position that is fully funded with state funds, and then partial of my position is funded with state funds. The remaining positions that we have are funded through IDEA federal funds. As I said, we had the monitoring process that would do 6 districts a year. If we are to increase our monitoring and increase the activities that we do, we would need more people, and we are looking at how we would adjust that so that we can add more staff to our bureau. We have 3 offices within the bureau: the Office of Training and Monitoring, the Office of Data and Finance Management, and the Office of Special Programs, which oversees some of the grants that we apply for, other grants that we apply for, and some of the other initiatives that we fund. UDL, Universal Design for Learning, is one thing that we work on. All of our accessibility for the deaf and hard of hearing, as well as the visually impaired. Our monitoring currently has 7 staff, and we're looking to increase that so that we can provide more training and we can provide more monitoring of districts through their indicators, as well as looking at their program approval pieces going forward.
May I continue? Has the department made a request for resources to bolster this, to try to address these
We have not, no.
process concerns? And is that something that I think it might be helpful for us to see what is the organization
Sure.
that you might describe, maybe just an organization chart or flow?
Yep, I can forward you the organizational chart. Sure.
And you know, that with the quantification of caseload might begin to give us a sense. There's clearly a need for resources someplace.
Sure.
And you might then describe that if there were more resources, here is how the department would apply those. Thank you.
I just need to take notes, sorry.
Now I have a question for you.
Sure.
Okay. You talked about monitoring the district and see whether or not they're following the guidelines. Do you have any way of enforcing if they don't?
So we, there are several things that we can do. They have to, by law, they have to correct whatever we found that is non-compliance within 1 year. And then we do a follow-up to see that they've changed their practice. So if we found that they weren't implementing an IEP correctly, they would have to correct that IEP. And then we would come back and look at another student's IEP and say, did you correct your practice? If they do not correct their practice, there would be more intensive there's different levels, so it would be more intensive monitoring up to it, but not just taking back some of their funds and withholding funds. So unless you meet our requirements for monitoring, we could withhold their federal funds and say, we need this done before we can release the rest of your funding.
But it seems to me that a year is a fairly long time to wait for anything to happen.
Yeah, that's the guidelines that are set forth for us through
Okay.
the Office of Special Education Programs.
So if you,
And we don't take that year. I mean, I mean, our process is a year, but we had been providing technical assistance up front. We were providing trainings. We would typically be back in that district within 60 to 90 days to check on those IEPs that we
Okay.
had issues with.
so if you withhold federal funds, is that gonna affect the rest of the kids and their education?
Yeah, it's gonna affect the IDA special education funds that are provided to the district for the other special education students. So it's not something we would want to do. We would want to work with the district, talk with the superintendent, and try to come up with a plan to make corrective action towards
Okay,
towards that end.
thank you very much. I see Kate Shea has arrived. She wants to testify.
Thank you.
In true fashion of mom of four, I'm kind of flying a bit by the seat of my pants today. I have nothing formally prepared, but I ask for God to help me speak from my heart today because I'm not here for myself. I think I shared last time with the House Committee that I have since pulled my 3 boys that were part of special education out of the system. I couldn't do it anymore. It wasn't good for my physical health. It wasn't good for my mental health. So I'm here to support the Bill 381 to provide for an advocate in special education. I've been up to testify several other times on different bills related. Won't take you through the long, sordid story of how I got here, but I can tell you the bags under my eyes aren't because of lack of sleep, just because of my kids. It's because of the parents that reach out to me 24/7 in the state that desperately need help. And I feel obligated to step up as a citizen, speak up for what's right, and to say what we need. And we need more than ever during this time of a pandemic to help these kids that are marginalized, that have such huge potential, that are literally on the edge of the playground. There's actually a book or something called Edge of the Playground. These are your kids walking around the playground looking like they're in prison. And they're not getting the supports and services that they need because of the process that you guys have heard about in previous testimony. I won't take you through all of that, the whys and whats and hows. You'll hear about that there are OCR processes, right? And that there are due process processes in place, but they're broken. For whatever reason, they're not working for the people. So a parent has to literally be almost a lawyer to understand the process and go up against Goliath. It is a very weighted process on the favor of government and on schools even. And it's not doing any favors to teachers either. When these kids can't get the help that they need in classrooms, it is going against the teachers as well. So I sit here, in favor of teachers as well. This is not a problem with families not doing what they should be doing, with teachers not doing what they should be doing. It's that the system's just broken, and we need somebody to fairly come in and help adjudicate these processes and to cut through some of the red tape. I think I just heard someone alluding to a year worth of time, and I nodded my head because I said, you know what? In some of my kids' cases, it did take a year's worth of time just to get an IEP. Who has that kind of time? And we're talking about formidable years of a child's life, right? The Catholic Church used to have a saying, and I'm not saying this because I'm Catholic, I'm not. You teach a child by the time they're 8, you've got a foundation laid, right, for what their future is going to become. The foundations of these kids are being completely obliterated right now because there's not a fighting chance to get an IEP in place in time, to get them the supports and services. It leads to mental health issues. It just fuels the system and it keeps going and going, almost like a cycle of abuse. And it's abuse to the teachers, frankly. I mean, I came from a family of teachers. My mother was a school teacher. My sisters are teachers. It's not doing anybody any favors to not admit we have a problem. I know you've heard testimony from others saying we don't have a problem, but over 700 people signed a petition in this state. And I can tell you as a parent advocate, not because of me or my kids anymore, because remember I took them out and decided to handle it my way. But I can tell you that people in the state are afraid to speak up because there's real retaliation, there's real consequences for speaking up. Some of that's right in this room. So when you've heard from people, 700 plus people, that we need to do something about this, that should be multiplied many times over. There are many people crying out for help. And as I said before, the bags under my eyes are because people are reaching out to each other saying, hey, I'm just headed down this path. So we all try to throw each other a lifeline and say, we'll help you along, we'll help give you the process. But then they don't get anywhere. And what no one tells them is, you're not gonna get anywhere. You're really not gonna get anywhere. You might get a tiny percentage of what you need, but you're gonna survive, and you're not gonna have a thriving citizen on the other end of the educational process. That's a huge waste of our dollars, right? And our time? I think. I work in business, and I'm in software engineering, and if we don't fix a defect up front, it gets propagated out to all of production systems, something we can't even recover from. We're in an unrecoverable process right now. This process has propagated a future of dependent citizens in our state that will be looking for SSI, welfare, you name it. We will not be able to sustain this model. It's not one that if accountants came in and crunched the numbers, they would walk away shaking their head saying, the state doesn't have a future. Because the model we have set up today, we're not helping ourselves. And it's not a money problem. It's a process problem. It should not take a year of time to get an IEP put in place. If I did that in the business that I work in, I'd be gone. So I'm just here to speak up for the people that can't be here. I had to run in between meetings and things and dropping kids off. But I made it a priority because it doesn't necessarily directly impact me, but it's the right thing to do. And it's the right thing for you to hear from the people that this is a problem. We wouldn't have gotten to this point of this bill getting to this stage if it wasn't a problem. So if you have any questions, I'd be happy to answer. I don't have any other facts other than, proficiency levels in our state for these kids are like at 13% for math, I think, 17% for reading, well, probably below that with the pandemic. And somehow that's okay. So since I pulled mine out, I have 2 boys that are playing in the woods, that are doing their VLACs, that are helping each other, that are learning, that are coming back with facts and talking about conduction and convection and all kinds of interesting things and finding things in nature. That's true learning. So, this is not a school choice bill, but we need to realize that we do have problems. We need to recognize that and do something about it. And you guys are empowered to do all that for us. But not acting and doing nothing just is dooming these kids to a future of dependency. And I can tell you, my kids were headed that way, and they were giving up, and I said no more. But I'm here to speak for the people that can't say that. They can't free their kids. I actually dropped one off this morning. One of mine is still in there, and she was in tears. So that's the state of our kids. The most vulnerable are in our special needs communities. They are smart. They have hope. They have promise. We need to give them a fair shot. We need someone to come in and to get through the red tape and give them that chance. Thank you.
Thank you, Kate. You do very well talking.
questions?
Any questions from the committee members? Don't see
Thanks so
one.
much.
Thank you. You have another meeting now? Okay. Thank you for coming. Thank you very much. Well, that concludes the testimony on Senate Bill 381 FN. Now, we go to 238. And hopefully this one will go a little faster. So will you take the,
Can you get through? Thank you. I'll open the hearing on Senate Bill 238, and I will call the prime sponsor, Senator Ward.
it's still good morning. So good morning, everybody, Madam Chair and the members of the committee. I'm Ruth Ward, Senator for the District 8. Senate Bill 238 requires chartered public schools to enter into a memorandum of understanding with a resident district of a student with disabilities who is attending the chartered public school concerning special education services. There are a lot of rules in both in the RSAs and in other areas about what to do. So the audit, it's a very short bill, but it also is a request that be audited, and it should include a review of the memorandum of understanding, so to see whether or not it's feasible for the charter school and the resident district school to do whatever they have to do. So that is the bill essentially, and I will leave it to those who know more about charter schools and memorandums than I do. And I think we have somebody from the DOE who can answer a lot of questions. Thank you.
Thank you, Senator Ward. Any questions? Okay. On that, I will call up Rebecca Fredette from the department.
Good morning, again. Currently, there is no oversight or agreements that are required of charter schools and public schools, charter public schools and public schools when a student attends a public school, attends a charter school. Once a student attends a charter school, they are still the responsibility of the resident charter public school that where they reside. Sorry, I'm having trouble with my public and private wording. And so the residential school, where the resident district where they reside, is still responsible for a FAPE and is still responsible for all special education. At the department, we have heard both from charter schools and from public schools that there are issues between charter schools and public schools around the agreements that have been made, around how services are provided to students, how fees are determined by charter schools or fees are determined by special education directors at public schools. And by instituting a memorandum of understanding where you lay out all of those pieces ahead of time, we feel that this will clarify for both the charter school and the public school what their responsibilities are in providing a FAPE and providing special education to those children that they both share. So that is the intent of this bill.
I have a question. Sure. So was this at the request of the department? Yes. Thank you. Any other questions?
I have a question.
Senator Ward?
Who initiates the process? The residence school or the charter school?
I would think that it would be a collaborative effort, but it is, we have put it into the charter, we are saying that it is the responsibility of the charter school.
To reach out first to be sure that
Yeah.
they have it. Okay, thank you.
Thank you, Senator Ward. Senator Khan.
Thank you, Madam Chair. The charter school might have several school districts
Yes,
that they need to negotiate this with.
yes.
And you probably envision that the first agreement might be a little bit clumsy in negotiating, but as one district or one charter enters into this, the second year will be easier. The second charter that might copy the first charter's agreement. And there's a small implementation phase, but in the end, this should be able to be worked out fairly routinely after initial period.
Yes. And there has been, after this bill was filed, there had been a suggestion that we potentially provide a template for an MOU. And we would be willing to do that if that was something that was requested.
Sounds like a great idea. Thank you.
Welcome.
Thank you. Any other questions? Okay, thank you.
Thank you.
Next, we have Jane Bergeron has signed up to speak but has not supported or opposed the bill. Do you want to check a box?
We don't want to check a box.
Okay.
Good morning. My name is Jane Bergeron. I'm the Executive Director for the New Hampshire Association of Special Education Administrators. And I'm here representing over 170 of our members who are leaders in the field of special education. As you will see in our testimony, we certainly see the value of this bill and the value of a potential memorandum of agreement with charter schools. As Becky had mentioned, our leaders of special education on a regular basis have difficulty in terms of a variety of things when it comes to the provision of services for special education in our charter schools. And as Becky had noted, it is the resident school district that has the legal responsibility for the provision and oversight of all of the special ed programming going on in the charter schools. We are bringing forward to you in our testimony some suggestions as you think about a memorandum of agreement, one of which is we would suggest that the Department of Ed consider some kind of rate setting. When there are charter schools who have individuals within their schools, let's say a speech language pathologist or a reading specialist, they can charge the school district anything that they want. There is no agreed upon consistent rate from charter school to charter school. So our private special education schools have a rate setting process with the department. So we'd like to have that considered as part of the memorandum of agreement. And the other point that's in our testimony is that we would like to be a part of the collaborative development of a memorandum of agreement and work with the department and the charter schools collaboratively in terms of what the content should be for that memorandum of agreement. So please know that our association is happy to assist in any way, but these are the things that we'd like to have considered before we can fully support the bill, but we do see the good intentions behind it and would open it up for any questions that you might have.
Thank you. Any questions? Senator Khan.
Thank you, Madam Chair. Ms. Bergeron, would you take a look at the text here in paragraph 8 and maybe on line 7, but I mean, the charge is not very complex, it seems, and you have suggested rate setting, which might be a range, right? But whatever it is, you might suggest wording that would be satisfactory to you and your members.
Yeah, we'd be happy to help with that. The department already has a process for rate setting with our private special education schools, and I think we might be able to mirror some of that and would look to Becky for more insights on that. But it's been a problem with the inconsistency.
Follow up? No, just your suggestions will be welcomed, I think, by the committee.
Thank you for the question.
Thank you. Any other questions? Thank you.
Thank you.
We have someone who did not, I cannot read who signed in, but they are not supporting and they are not opposing and they do not wish to speak. And then we have Matt Southerton, who would like to speak, not supporting and not opposing.
I think I turned it off. Sorry about that. Good morning, Matt Southerton. I've worked with charter schools for approximately 20 years in New Hampshire. I'm a board member of the New Hampshire Alliance for Public Charter Schools. This bill came to my attention after I spoke with about 15 schools a week and a half ago. They're very concerned about this bill. If we go to the 50,000-foot view, we would consider having contracts, obviously, with all of your districts to delineate all of these different items would be a best practice, right? Having the state create additional bureaucracy in the form of an MOU and enforcing it through the mechanism of the program audit, we don't feel is necessarily a good idea. And I think we're going to you would introduce potentially a lot of unintended consequences. So, for example, what happens if I run a charter school that has 25 or 30 different school districts, And I try to fashion MOU with those 25 or 30 different school districts, and 5 or 10 of them just simply won't engage with me on that. You've put all of the burden, all of the emphasis on the charter school in this bill. My school comes up for a program assessment or perhaps for charter school renewal, and those, we go before the Board of Education and they say, hey, 33% of the districts that you work with did not sign an MOU. How would that reflect on their renewal prospects? So that's really a serious issue. I'm not an expert in special education. We had hoped that one of our board members would be able to show up, but unfortunately she just tested positive with COVID today. She's doing well. But she had said that what she thinks that will happen in this event is that we could run into an issue where pre-existing contracts could be you could run into the event where you have pre-existing contracts with school districts around the state, and that global MOUs from the department could interfere with those, and then we would need guidance on how would we deal with that. So we are not supportive of its current language, but generally speaking, having a contract with every school district that you do business with and that provides services for special needs students is a very good idea. And our schools endeavor to do that.
Thank you. Any questions? Senator Prentice.
Thank you, Senator Hennessy, and thank you for testifying today. So just for clarity, if the language, as I'm hearing this, if the language of the bill incorporated collaboration, okay, and a mechanism to recognize current agreements that were in place, because that's been done before in other, when I think about like other, municipal. I'm thinking from the municipal side, if there was a way to do that,
To grandfather in.
to grandfather in some language, because I don't think that, the intent of the bill, pretty clear. I think it could, we could advance this in some areas for clarity, but I've already heard about collaboration once, and you're number 2, and I think that there's, that most success comes from collaboration. But if there was a way to recognize pre-existing relationships, okay, I'd want to know a little bit more about what those said, but I think that there might be a way to get it. This will be up, obviously to the committee and Senator War, but there may be a way to get at that.
Yeah, no, I agree. Again, it's a best practice to have a contract with each school district. You need to make sure that the students get services on time. The charter school gets paid on time. I think that the state really needs to flesh this out a lot more. You need to be very specific of what you would want to see in this. Because you can't just simply use this global statement, and it can't be ambiguous. If you want a global MOU or contract that every charter school in the state has to employ, and there needs to be some sort of buy-in with the school district. The school district is going to have some sort of skin in the game, where it can't just be the emphasis on the charter school to have to make sure that this contract's signed. Either that, or you're going to have to remove it from the program audit so that it can't be used against them later on in a charter school renewal in the event that a school district won't sign it.
Follow up? Okay, thank you. I have a question. So you spoke about contracts that are already in place and that your fear of a global MOU that would come down from the department. I don't understand for myself what the difference between a contract that's already in place and a memorandum of understanding, because to me, that contract is a memorandum of understanding.
Well, a memorandum
sorry,
of,
just one
sorry,
second. So my question to you is, if these districts already have a contract in place, which is great because there's collaboration going on and we all want to see the best for these kids, why would this bill interfere with that when the department is being, in my opinion, has written it so that to not interfere with contracts that are already in place and not dictate exactly what needs to go into that memorandum of understanding?
Well, again, I think that additional burden, that's open up to interpretation, right? So on one side, we say that we want to define what's in the MOU, right? We want to provide guidance, want to provide a template. well, what if the items in the contract are not in there, in the MOU? And again, not all MOUs are enforceable, right? You have to have the language within an MOU that would make it enforceable. So an MOU can simply be guidance between two entities.
Any other questions? Thank you.
Okay, thanks.
Next, we have Russan Chester. Not supporting, not opposing, and did not sign if she would like to speak or not. Nope, Russan. Okay, and then that is it. Do we have another sign-in sheet? I'll ask. Diana Fenton, would you like to clarify anything?
I'm happy to do so if the committee would like me to. Good morning. My name is Diana Fenton. I'm an attorney for the Department of Education. And I might just finally be before this committee to speak on something other than criminal background checks. So I think we can all appreciate that since I'm getting quite the fan base on YouTube currently. So I'm happy to take any questions. I did have the privilege of authoring this particular piece of legislation that is in front of you for your consideration. I think the thought was to recognize the importance of an MOU because it sets out the expectations for both parties. And we do that consistently in state government when the Department of Education will partner with one of its sister agencies, whether it's DCYF or the Department of Safety. It's not a contract, it's an MOU. It sets out what the expectations for both parties are, and it really provides clarity as to each individual entity's role, and I think that was I know it was the thought with this proposed bill in front of you, recognizing the importance of special ed services and the complexity, which this committee has heard about in previous bills this morning. And I thought, the thought from the department, the intent was just to have that opportunity to lay out what the groundwork would be. Senator Hennessy, I do agree with your comment that in no way, shape, or form was an MOU ever thought to trump or override a contract that was currently in place or would in the future be in place. The department had no intention of undermining those currently existing legal documents, nor does the department believe that an MOU would have that legal effect. So I'm happy to take any questions, and I thank you for the opportunity to provide that clarification.
So I have one question for you.
Sure.
So, thank you. If a chartered public school already has a contract in place with the other public schools, would they need an MOU, or is this bill intended to address other issues?
A hard question to ask because I'm not sure what each particular contract would cover. So it's hard to answer that question without getting kind of drilling down into each individual contract. But I think the idea of the MOU is to say in general, these are the items which should be taken into consideration and be addressed. So if you look at the chartered public school law and they list out the items that are required in the application, the department envisions it similar to that, right? We don't drill down to say exactly what each item should consist of, but there is an enumerated list in the statute that says these are the items that have to be involved in your application. And it could be similar to that. These are the items that need to be considered. And I think the MOU, again, is a tad premature because the department hasn't done anything to draft it or provide technical assistance. But there could be some language to say you could have a contract that already encompasses these issues. Again, I think this is guiding documentation, guiding language for charter schools and districts.
Thank you. Any other questions?
Yes, Madam Chair.
Senator Ricciardi?
Just more of a comment. I go back to my experience with MOUs as being a town councilor, and the way that I view it, and correct me if I'm wrong, is it really just clears up blurry lines.
Absolutely. I would agree with you, Senator Ricciardi. My first experience with them was years ago when I was a criminal prosecutor in 3 small towns. We had an MOU between all those towns to understand what each entity's obligations were, what the expectations were, and kind of the common practice. And it's a nice document to take advantage of because it doesn't have the legal consequences of a contract, but it does make things very clear when 2 entities are working together.
Thank you. Follow-up?
No, thank you.
Senator Khan.
Thank you. There are 13 areas in IDA, 13 categories of service. Would you see that? I mean, this just doesn't seem that complicated to me. I'm sorry to say that. So the kind of things that are being asked for, and I see that you've collaborated with Senator Ward to develop this.
Yes.
I think I heard from Mr. Southerton that he's interested in seeing that if there's some audit or consequence to charter schools, that maybe we can find a statute that ties public schools to these agreements so that there's some balancing of interest for both parties to participate. Maybe that could be added.
Well, at this point, this bill is in your capable hands for any amendments that you deem appropriate. But the department has a long-standing working relationship with all our stakeholder partners, and so the department would not be opposed to any such amendment or further discussion. We appreciate the opportunity to work with Senator Ward to bring this idea before this committee, because I think regardless of the end result, I think it's very clear from this discussion that the idea has some merit. What it ends up looking like, it's to be determined, certainly, but the concept is very valid.
If I could continue, this has been an issue before. It seems that we're pretty close. If you could, with your good knowledge of and working with anybody else in the department, could help us on second paragraph to add that balance. And I think together with what we heard from Ms. Bergeron about rate setting, or maybe adding something of guidance, specificity, I think Mr. Southerton said as well in line 7. I mean, we should be able to get this resolved.
The department has its marching orders. Understood.
Thank you.
Thank you.
Thank you. And with that, I will close the hearing on SB 238 and turn it back over to Chairman Ward.
Thank you, Senator Hennessy. Now, the next bill we have to consider is SB 394, relative to the definition of a child with disability under special education laws. Senator Khan is the prime sponsor.
Thank you, Madam Chair. And for the record, Jay Kahn, State Senator in District 10, representing 15 of 23 towns in Cheshire County. Senate Bill 394 is dealing with a problem regarding the state's definition of access to special education services. Our current state definition is that it is the responsibility of school districts to provide special education services to age 21. And as such, that is something that is described in RSA 186C2, which is being amended with this bill. So the practice to 21 years of age. The bill is, well, let me back up. The federal IDEA definitions are that special education would be offered through one's 21st year. So state law is permitted to set a definition independent of the federal government and should the state not have a law, then the federal government definition would apply. We can, and this bill here is attempting to put into statute what is the current practice of our schools, which is, by and large, according to the Department of Education, the practice in schools is to go through the school year in which a child turns 21. So it's finding the difference between these two definitions. Again, most school districts are not saying that when a student turns 21, their IEP and their ability to seek any kind of educational experience through the schools is over. Most schools are going, allowing that IEP to be completed through the year in which the student turns 21. And that's what this bill is attempting to do. The Senate considered this 2 years ago, and Senator Ward and I will remember that consideration, I think, because we ran into, just was there a right answer? At the time, we punted on this and said we'd come back to this another day, and I think this is the other day. So this is trying to strike a balance between meeting parental interests, keeping a child in school through the IEP in the school year, and continuing with other students that they know and helping to promote the transition to economic self-sufficiency and independent living. And that's what most schools practice. Next to doing nothing to clarify the state's definition, this solution has the least financial impact on our local school districts. It doesn't just move the goalpost 1 year further out so students abruptly lose services when they turn a certain age, like 22. And it limits the tension of having a post-21-year-old student in a class with students who are under 21, and consider that for a moment. Between the ages of 17 and 21, students who need ongoing special education services are often, when it's an in-school program, are together. The good thing about the current law is that it makes sure that nobody turns 21, has privileges that other students in the class do not have privileges to do, and avoid some social difficulties that schools otherwise will experience when 21-year-old students are in the classroom. I think, I don't think that there is a perfect solution here. I do think that the one being proposed in this bill is the best one. It's followed by 10 other states, and I appreciate the testimony that we received, written testimony from Ms. Dunham, that details the range across our 50 states. Notice there's no majority opinion on this across the 50 states. There's a whole range of different definitions of when special education services terminate. I think this is the best one for our state. It's one that is in practice. It has the least financial impact, and is not a downshifting of costs onto the school districts unfunded. And I think it's the best we can do for our special education students, is to see that they can continue their education through the last year of their IEP in full, to help smooth their transition to independent living and self-sufficiency. Thank you, Madam Chair. Glad to take any questions.
Thank you, Senator Khan. Questions from the members of the committee? I see none. I just have I don't know if this question is just clarification. You mentioned that now you have a 21-year-old in the class with less than 21-year-olds and some of the privileges that you have when you get to be 21. Do you foresee any problems, or should we put something in that they will still have the same expectation as the one less than 21-year-old? When they can't stand up all of a sudden and act like a 21-year-old.
They cannot. I think because the practice is in place in most of our school districts, the information that Ms. Dunham provided is that we're talking about a population of 153 students. And when the Department of Education last did this survey to define or determine the range of services to that 153 students, they observed that only 40 of those students were not receiving education services through the school year. So I think it's a small population, a small number of districts that might have to adapt beyond what they're currently doing, and I guess I hope that this is all manageable.
I think it's an excellent film, and I hate to see somebody just because they turn 21 can't finish up the school year. So I'm totally in support of it.
Thank you, Madam Chair.
Thank you, Senator Khan. Jane Bergeron.
Good morning. My name is Jane Bergeron. I'm the Executive Director for the New Hampshire Association of Special Education Administrators, and I'm here representing our members. At this point, our association isn't ready to take a stance in terms of supporting or opposing, and would like to just bring forward a few additional items for your consideration, and both of which center around the fiscal impact upon our educational communities, and making sure that the fiscal note really accurately represents all students with disabilities in that age range. So the data that you will see in the fiscal note is relative to students who are in residential schools and separate schools, which would be a special education day school. So there are a significant number of students in this age range who would qualify, who attend our public schools. And many of those students tend to be our most complex. They tend to be those who need the most services. Many of them have one-to-one paraprofessionals. Many of them have nurses assigned to them. Many of them need behavioral supports, specialized transportation, and medical assistance. So they tend to be our more complex, more costly students who need a lot of support. The other thing to take into consideration is a big portion of this population who are in our public schools also participate in community programming, which includes transportation, job coaches, and pretty typically our districts contract with independent vendors to do that work, and it's pretty costly. And so we would ask that you really take that information. I think maybe the department could help us. If our association needs to help you get that data in terms of numbers, we would also suggest that if this were to be a start date of July 1, none of our school districts have budgeted for this. their budgets for July 1 are done and being presented to their local community. So this could have a significant impact on our educational communities and their budgets, and we just want to make sure that that information is accurate. And we'd open it up to any questions that you might have.
Questions from the committee members? Senator Khan.
Thank you, Madam Chair. What effective date would you suggest?
July 23.
Thank you. And I assume you recognize the risks that the state Department of Education faces with the definition that we currently have and the conflict between the two definitions from the federal level and the state level.
Well, and I can't speak to the in-depth legal aspects. We did have Attorney Zellen send to you. I think it was sent off either last night or this morning. Some more in-depth details in terms of his legal interpretation of that. And in my testimony, I did include the federal definition of students with disabilities, and currently we don't serve students to 21 for general education. So we feel as though there isn't a significant conflict in terms of federal and state law. But I'm not an attorney. Jerry has sent some information to you, and from our lens, we're not in jeopardy.
You said somebody has sent some information?
Attorney Jerry Zellen, I believe, emailed it to you maybe last night or this morning. Okay, I saw it this morning as I was coming in.
Oh, the gentleman with some, okay. Okay. Thank you.
You're welcome. Thank you for the question.
I have to read through that one.
Gives you a lot of information.
That's good. That's what we need. Any other questions? Seeing none, thank you.
Thank you.
Bonnie Dunham.
Can I have to take off my mask, not my glasses? Sorry. My name is Bonnie Dunham, and I'm here as a parent, a private citizen, asking you to support this bill. My son has significant disabilities. He's a grown-up now, and so he's been out of school for quite a few years, involved in adult services now. He received special education until the day he turned 21, which was in November. And so on that date, special education ended. Because we had collaboratively worked with our district, his program from the date that he went through his graduation ceremony in June until his 21st birthday was community-based, so that he could learn how to put into effect the skills that he had learned while he was in the school building. And he completed his school career in the building with his classmates and wasn't there for the rest of that after that. I know that if he lived in any other state, though, he would have been able to stay in school for 6 to 12 more months. And for some students, that makes a huge difference. Some may use that time to complete a regular high school diploma. In the Department of Education, the last data I could find was from the state performance plan and annual performance report submitted in 2019. 1,789 students with IEPs graduated with a regular high school diploma in 4 years. When they looked at a 5-year cohort, another 231 students with disabilities earned a regular high school diploma. So for some students, that extra time could result in a diploma, which, as you know, has long-term implications for being more independent, being able to hold a better job, and so on. Our state special education law that says that special education ends at 21, on the date of 21, it does meet the letter of IDEA, because IDEA does allow states that, where it's in conflict to obligation to provide a free, appropriate public education does not apply to children 3, 4, 5, 18, 19, 20, 21, in a state where that would be inconsistent with state law or practice. And New Hampshire has decided to take advantage of that. And I know when I go to national conferences, I'm proud we're the first state to close our institution. I'm proud that we involve parents and have more rights to include parents in the process than other states. This is the only place where I'm embarrassed that we end special education before 21, or before when a student turns 21. As Senator Khan said, of the 50 states and the District of Columbia, only 7, in addition to New Hampshire, do not provide special education beyond age 21. It doesn't make sense that we would do less than 43 other states. It's not typical for us. The only other exception is for incarcerated students, and so it's those pretty slim exceptions. By allowing that extra time, we'd be using being closer to the default age for students with disabilities, and not having some students have to leave school. Some students do stay in the school building, and there are instances that I've heard of where on their 21st birthday they just had to walk out and had to leave their friends, their classmates that they were in school with. And while they might be able to come back in June to go through the graduation ceremony, they've lost important connections. The number of students would be small. The statewide census said there was 159 students ages 20 to 21 receiving special education. And so that's the only group that would potentially continue. The number declines every year after students turn 17 and 18-year-olds, and small number, 18 to 19, smaller, and so on. And so I would expect that decline in numbers would continue if we extended to the end of that school year. And the reality is it would cost something, no doubt about that. But I believe it would be fairly minimal. A significant percentage of those students, 3/4 of them who are still in school at age 21, have disabilities that would likely make them eligible for adult services, like what my son receives. And in some instances, families decide to leave school with their children before the age of 21 even, because they find that adult services may be a better fit for their student. Others continue on. And so some students may leave before the end of that school year. The other piece is that most of those students, because they're complicated, are likely eligible for Medicaid to schools funding, which would further reduce the financial impact on school districts. The majority of students who are covered also, as a taxpayer, I know I'd be paying for those students regardless of whether they stayed in school or entered adult services. Both services are funded through taxpayer dollars, and so whether the money goes to a school district or to an adult service provider, I could understand schools would rather it didn't come out of them because it doesn't look as good on paper, but the reality is the taxpayer is being impacted pretty similarly. Both of those systems are tax funded, but for those students who would continue, they may earn that regular high school diploma. They may use the additional time to achieve transition goals and be more ready for employment, post-secondary education, and independent living. That seems like a wicked sound investment, and so I encourage you to support this bill.
Thank you very much. Questions from the committee members?
Thank you.
I don't see any. Thank you very much.
And I brought copies if anybody did.
Now, Catherine doesn't want to speak. Megan Tuttle supports, doesn't want to speak. Roseanne didn't sign off on any of the boxes. We have had a lot of virtual sign-ins as well. Senator Hennessy?
Thank you. I have a question for the department. No, it's a money question. So, in the written testimony we received from Gerald M. Zellen, it says that the numbers that were given don't identify the kids that go to the regular public schools, and those could be upwards of $10,000 per month per student. If this bill makes it to the Finance Committee, could we have better numbers to identify what the actual cost would be to our school districts for the students that go to public school?
Yes.
Thank you.
We can get those numbers for you. Did you have any other questions while I'm here?
That concludes the hearing on whatever it is. Senate Bill 394. Now for the final bill, Senate Bill 426. Let's see who Senator Khan is the prime sponsor.
All right. And for the record, I'm Jay Kahn, Senator from District 10, which includes 15 of 23 towns in Cheshire County. I'm introducing Senate Bill 426, which regards the adequate education grants for the fiscal year 2023. So we're looking forward 1 year here. To try to do in fiscal 23 what was done in our appropriation process for fiscal 22. When we were at this point 1 year ago, this committee, considered both through a bill from Senator Hennessy and another one that I introduced, something comparable, which was because of the pandemic, there was a pretty dramatic drop in public school enrollment. 1 year over the next, from fall 19 to fall 20, of about 7,000 students, and maybe closer to 6,600 students. But nonetheless, something that wasn't explainable just through an age difference rolling through the school system. And because of that, we established a mechanism for developing a floor for enrollment that used the higher enrollment for either fall of 19, fall of 20, or fall of 21. And at that time, we envisioned, well, the pandemic will end. We'll all do a great cheer and feel much healthier and safer. And lo and behold, here we are a year later, not having made a proper prediction on the enrollment that there would be for fall of 21. In fact, fall of 21's enrollment is lower than it was in fall of 20, and significantly lower by 8,000 students now from where it was in fall of 19. So what the bill is proposing is that the language, and this is just an amendment to session law, not a change in chapter law, is that we use the same methodology for the allocation of adequate education funds. We use the same methodology in fiscal 23 as was adopted for fiscal 22. And yes, because there are more students, there's a cost impact. That cost impact was addressed in a fiscal note provided to this bill, but it's also provided for in a memo that we received this last week from the department and Mark Manicinello about our allocations to education for adequate education and SWEPT grants. And I hope we can put to rest the debate that sometimes we have on the Senate floor as to how much money was provided to public school districts in fiscal 21 and in fiscal 22 and budgeted for fiscal 23. Because it should now be very clear to us that the allocation for fiscal 22 is in fact $24 million less than it was in fiscal 21, and that the allocation for fiscal 23 is in fact $58 million less than it was for fiscal 21. So hope we can all agree to that. The difference in fiscal 21 is because fiscal capacity disparity aid, which was provided in fiscal 21, is not provided in fiscal 22. That's the straight up difference between what's in the 22 budget versus 21. That explains the $24 million decrease in those 2 years. The fiscal 23 loss is a bigger loss, $34 million from 22, and that's entirely because the enrollment offset that's provided in fiscal 22 is not provided for in the fiscal 23 appropriation. So I think there's a great opportunity here for our committee to do a bipartisan approach to trying to stabilize the amount of money going to public schools through the Senator Hennessy's Senate Bill 420, which provides for extraordinary need $14 million. The cost of stable or arriving at the same smoothing of enrollment as we used in 22, move that to 23, and which costs $30 million. You put those together, there's still a decrease, but it's a minimal decrease. It's small. I would explain it as being minimal, $13 million decrease from fiscal 21, but we will have done everything that we could. Yeah, and I'm not bringing up disparity aid again. We've dealt that issue with that many times over. We have a proposal for extraordinary need. We have a proposal for using the same enrollment definition for fiscal 23. We've already dealt with the poverty factor in the fiscal 22 and 23 budgets that was in fiscal 21. We could walk away from this 22 session with an appropriation for public schools for fiscal 23 that will have done everything that was done in fiscal 21 and almost arrive at the same place. Different definitions, different programs, but a similar outcome. And I think if we can share in that goal, we can arrive at a very good outcome in a bipartisan way. And it would be to the improvement of services to our students, our state, and to our taxpayers to do this, who ultimately will see the consequence of a $58 million decrease in public school funding in their tax bills. So with that, Madam Chair, I conclude and glad to take any questions.
Thank you, Senator Khan. Senator Hennessy.
Thank you, Senator Khan. So I'm trying to understand what this bill actually does. And the way I read the methodology section, is that it's going to give $30 million in fiscal year '23 only. So again, would create another blip in our funding issues in our state, to districts who saw a drop between either 2019 and now or 2018 and now, for students who are no longer in our school districts that are English language learners or special education students.
Well, it covers base adequacy.
It says that the bill does not change ADMR related to differentiate for free and reduced lunch meals students.
Because that's already been accomplished for fiscal '23.
So I guess my question is, again, this is one-time funding. I don't like one-time funding things because it always creates a blip in unsteady funding for our education in the state. And it says to our local districts, hey, we're going to increase your funding. And then they're always surprised the next year when they don't have that funding. So if the kids didn't come back, and again, as a perspective from somebody who lives with 2 kids that go to public school, and I saw kids leave our public school systems because they wanted their kids to be in person. And this was March of 2020 into the fall of 2020, spring of 2021, until the governor said, you have to be in person. The kids have to go to school 5 days a week. Until that time, I knew families that were either homeschooling their kids, found another place for their kids to go to school because of the difficulties of the back and forth with kids either going 2 days a week, 4 days a week, no days a week to actual public school. But I have not heard that this is an issue for this school year. So why, when we have the numbers for kids who have been back in school full time in the fall of 21, which would create the calculation for the fiscal 23 funding, why are we still having this issue with the numbers?
Well, that's a good question. Why are we? Let me address the blip first. If you think this blip is bad, what about the swept blip that we introduced with a $100 million difference? I think the point here is that didn't change the total amount of funding that's available to the schools. That just is a replacement, a one-time replacement. We're going to come back in the next biennium and look at school funding. There's no question about it. It's a mess. We're not doing ourselves justice in the way that we're allocating our funds into public education. It's a bunch of pieces, and it needs to come back and have a better resolution. Where did the students go? It's a good question because they didn't go into education freedom accounts. We know that those counts. There are only 204 switchers between one year and the next, meaning students who completed a school year in public school in 2021, who in fall of 21 didn't come back to those schools. So where did those 7,500 students go during the pandemic, or the 88,000+ students that it's now that number? And the fact is we don't know. We don't have good information here. But let's hope we come back another year from now. We have better data. We do the same thing that we did this last year, this year, in this coming year. Hopefully we have conditions that are healthy for students to be in a congregate setting and safe, and that the teaching staff is safe and healthy. We don't have the kind of disruptions that have occurred over the last 2 years. I understand the kind of consequences that families have faced, and they've made tough choices. Clearly, data suggests a lot of women have taken on childcare and teaching responsibilities in the home that's keeping them out of the workforce. So I think this is the right thing to do. I really do. This is not just how do we find the next lever to provide more funds to public education. I think the same conditions that existed for the Finance Committee and for this legislature to enact the fiscal 22 allocation and the enrollment compensating factors exist for fiscal 23. The conditions are unchanged. And our school districts, this is a message that, you know, we didn't intend for another $34 million reduction to occur in fiscal 23 in the middle of a pandemic. So let's try to find a way to arrive at a closer figure and send a message that we are wanting to support public education through this crisis and come back and recognize we're not in the right place on education funding. And we need to get to that, and we'll do that in the next biennium, hopefully. But I think we can do better for fiscal 23, and that's, I think between the proposal, Senator, that you've put forward on extraordinary need, it's a modest amount, but together with this enrollment compensating factor, I think we arrive at a true amount that is the will of this legislature to provide consistency as best we can during this tough 2-year biennium.
Any other questions from the committee members? Thank you, Senator Khan.
Thank you, Madam Chair.
Mark Manganiello. Are you ready to address some of these questions?
Hello, for the record, Mark Manganiello, Administrator of the Office of School Finance with the Department of Education, and I'm available if anyone has any questions.
Senator Hennessy.
Thank you. Thank you for coming to help us sort through this. I have a few questions for you. So could the department get us the number of students broken out by each of the categories that this would fund? I only see a dollar amount total. And have the school districts reported to you in their numbers? So we have a declining enrollment in general across the state every school year. Some districts may see increases in certain class sizes, but overall we have a declining enrollment. So how much of this blip in funding that Senator Khan has proposed is related to our declining enrollments, and how much is related to kids who have left the school system and are choosing not to return after the pandemic because they're doing VLACs, they go into a private school, they're being homeschooled, and how much is related to, I don't know what the other option would be.
I think I can, without getting maybe too into the weeds or technical, essentially 100% of the increased funds is due to declining enrollment because it's an enrollment hold harmless.
Does the department have any idea, sorry, let me phrase it a different way. So due to a decline in enrollment, does that decline in enrollment, because again, we weren't given the actual enrollment numbers, we were just given a dollar amount. Is that declining enrollment in line with declining enrollments amounts seen prior to the pandemic?
It's pretty close. I think it's enrollment changes every year. Consistently, historically, we saw about a 1% drop each year. We're going from, let's see if I have the numbers in front of me here. For 2021, 2022, we estimate, we don't have the ADM because the school year has not completed, but we estimate that ADM by the time we get to the summer will be 159,000. So the previous year it was 160,715 to end school year 2020, 2021. So about a 1% drop, or less than 1% drop. The consistent historical average is a 1% drop year over year. Sometimes enrollment does go up. when we were doing the state budget for 22-23 with the legislature, the governor's office, the Department of Education, we were all looking at the student data, and we all thought kind of that kids would come back to school. But now looking at the data, it looks like there's no jump in enrollment. There's no return back to school, at least statewide. For some districts, they are receiving return back to school. So this decline in enrollment is, I have to run the number exactly, I think it's about 0.5%, somewhat consistent with historical trends.
Thank you. And if we were to pass this bill, I'm looking at when towns and cities pass their budgets, and I'm thinking of this would perhaps get signed into law in June, July timeframe. But at that point, everyone's budget for fiscal 23 will have already passed. And so any funds that this one-time funding tries to target would then go to the towns as either excess funding, which they would have to elect to spend on certain different projects, or would go into the next funding bucket for the pool of funding. And again, I'm not using technical terms, but I just know that when my town received excess funding, it's going to reduce property taxes. It's not actually going to any educational purposes. Does that make sense?
Yep. So if any change to the adequacy formula is different. So for other state revenue sources, federal revenue sources, the way a school receives it and appropriates it has its own set of rules. Adequacy has a very specific set of rules on how adequacy gets to schools. So if you were to pass this bill or any school funding adequacy bill, and it were to increase the adequacy aid amount above the estimates that we just published November 15th, each school has the option to do nothing. If they do nothing, it will lapse to the taxpayers. It will reduce the tax rate, and the next time the tax rate is set, it will be a credit against the tax rate, so it will essentially go to the taxpayers. But they have the option under RSA 197.3a, is if the legislature modifies the formula, they can have a special town meeting. It's a little more streamlined process. They don't have to get petition a superior court. They can have a special town meeting and choose to bring that money into their school districts and appropriate it. So that's the two options, essentially, when you're dealing with adequacy and modifying the formula.
Thank you.
Senator Khan?
Thank you, Madam Chair. So, Mr. Manganiello, what I take from that question, and I think I know the answer, but I want you to verify it. If we act on this bill and these funds became available on June 30th of 2022, July 1 of 2022, the DRA in setting town tax rates would decrease the tax rate to fit the overall appropriation. With the additional state funds added in, it would decrease the tax rate, and in arriving at the total school budget. Is that correct?
So I just want to be careful. You don't want to say tax rate. It will decrease. DRA will apply all the adequacy to decrease the tax liability. It will decrease the tax rate, holding things constant, if they don't choose to have a special town meeting. So it will decrease the tax rate, holding everything constant, if they don't choose to appropriate the funding and take the excess funding and spend it on their school budget. But yeah, doing nothing, it will go against the tax liability of the taxpayers.
And have the effect of reducing my tax rate.
Holding everything constant. I don't like to talk about tax rates, but holding everything constant, yes, reduce the tax rate.
And everything constant means we haven't gone through a special meeting to increase the appropriation, which seems pretty unlikely that late prior to a school year.
There's, holding everything constant would also include other revenue sources. It would include your end fund balance. Just a lot of other factors, but yeah, essentially what you're saying is correct. I just want to use that blanket statement.
So if I characterize this bill maybe most accurately as a property tax reduction bill, that would be correct.
It provides an opportunity to reduce taxes, but doesn't guarantee the taxes will be reduced.
Well stated. Thank you. The memo that you sent us this last week, actually it's a table, right? So we've got an email with a couple of attachments in there. I found the table to be really helpful, not the one that went by town, but the one that, well, it showed the enrollment changes for each town over the 3 years. And you did that to cover a couple of bases, right? One was to show what the actual appropriation is for each town under current law, and then what the impact of enrollment is from fall 19 to 21. So we now have the information in that table that can help us understand this bill, right?
Yeah, that provides the 2021 adequacy actual, the 2022 adequacy estimate at this time, and then the 2023 estimate under current law.
And the enrollments that
the enrollment
would drive each of those.
The enrollment used to fund the adequacy formula, not necessarily the actual enrollment, the enrollment used to fund the formula.
Yes. Thank you. And thanks for providing that. I think it really helps us look across time at what the drop is in enrollment and funding. Thank you.
Thank you, Senator Khan. What was that thing you just spoke about? The list of the towns and the number of students for each years?
Do you have the date on the memo?
I believe I sent it out Thursday. I have to pull up my email.
I know I've referred to it many times.
I don't have it, and I would love it.
Oh, sorry. Sorry, I didn't bring a copy with me, and now my internet's disconnected. I think I sent an email to the committee on Thursday last week, and it had it addressed to the question relative to Senate Bill 420 with the how the extraordinary needs grant works as far as the who gets the max and then who's getting a sliding scale.
So you think that if I have it, it will be in my folder for 420?
Maybe.
Maybe. Okay.
Friday.
Okay, I don't have it, but it's. You don't either? Okay, thank you very much. Any other questions from committee members on this issue? Senator Khan.
Perhaps for ease of all the committee members, Mark, could you resend that memo so that we all have that?
I can resend that.
Thank you.
Thank you. Anything else that we need to talk about with this particular bill? Everybody's happy? Thank you very much, Mark.
Thank you.
Anybody in the audience who wants to contribute anything? Thank you all very much. This concludes the education hearing and on Bill 426. Thank you for coming.
Motion to move into executive session?
Second. Okay, let's see if we can deal with some of these things.
I'll move 420 ought to pass.
Senator Prentice seconds.
Aye.
Aye. That's 5-0. Do you want to put it on consent? Or do you want to talk to it?
I'll speak to it on the floor.
Okay, so
Thank
we
you.
won't put it on consent.
I'll take it out.
Okay, that's one. How about the study committee for looking at teacher shortage? The committee to study New Hampshire teacher shortage.
Senate Bill 236.
Senate Bill 236.
Move ought to pass.
Ought to pass by Senator Prentice. Second.
Senator Khan says he'll second it. You have a gentle voice today.
Any discussion on the bill?
I just have one comment.
Okay.
Thank you. Senator Khan, as the sponsor of this bill, would you consider reducing the number of senators to 1 from 2?
Are we recording our session? Are we recording this executive session?
It is being live streamed.
Yeah, okay. Then we'll keep our mics on then. So the reason for the 2 is I think that it's important for us to have some bipartisan interest in this bill. And I respect the fact that we try to limit our Senate and senators' time in study committees because we all get stretched very thin with too many of these. But on this one, given that there are likely to be financial implications to it, I think that having 2 senators allows for bipartisan participation of the Senate and consideration of more perspectives on the possible mitigating solutions to our teacher shortage, then and hopefully these recommendations can be brought forward in our next session.
Okay. If,
Senator Hennessy, is that a satisfactory response?
So no. No, I completely understand, and I do appreciate the bipartisan effort. I just, as a former House member, I had been in many committees where senators didn't show up because they were stretched too thin, and that was when there was just 1 senator assigned. So
I commit myself to being present at these meetings. Maybe the chair will yes.
Well, I think when it comes to the floor, if there's a big objection, I think the Senate President or somebody will state it and we'll go down to 1 or whatever.
Understood.
So other than that, do we have an ought to pass on it? Second? Who seconded it? Senator Khan?
Certainly.
And we have discussed it, so any vote? All in favor of it?
Aye.
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 That's 5-0. Do you want to take this on consent?
No, I think it's worth.
Pardon?
I think it's worth talking about on the floor. So.
Okay. So 5-0 and talking about on the floor. Do you want to take it out?
I can do
Senator
that and
Khan will
speak to
take it
at
out.
the same time. Thank you.
the standards board.
Did that.
What is that?
Oh, we haven't done that? I'll move on to that. 353.
353.
I'll second that.
Correct. Okay.
Yeah,
Any
just,
discussion
just
on
for
that?
just for recall, this is the one that makes tweaks to the term that people can be on the board. So the request of the department was that this be potentially 3 consecutive terms, and it changes the composition just a little bit to specify who the sectors that are covered by the standards board.
So we have not to pass on it. Any further discussion? All those in favor?
Aye.
Aye.
Aye. That's 5-0.
I move consent.
Consent on this one. All those in favor?
Aye.
Aye.
So that's consent. Who wants to take it out? Senator Prentice. And 386.
Do we want to talk about 394?
Which one is that?
This one.
The special ed
The age to
bill.
21.
Looking to see, I don't have it. Was it today's bill?
Yeah.
Yeah,
Oh,
394.
okay.
And we would need a committee amendment to change the effective date.
Madam Chair, we
We
do
can
have,
wait for, see
we
what-
have
if you want.
386, which was a department request bill.
So we're talking about 394? Is that what we're talking about?
Yep,
Okay.
we can.
394, could we hold that because we have some information outstanding from the
Okay.
department? Thank you.
You want an amendment to take care of the effective date, or can we do that within the committee when we get to that place?
And which one are you talking about now?
On 394, it was a
394.
request that we change the effective date to July 1.
Yeah, it was just July 23 instead of,
But we could do that as a committee amendment.
we can do that as a committee amendment. Is that okay with everyone? The
Yeah,
bill
that
is
is
suggesting
like that.
60 days after passage.
Madam Chair, can we hold this until we get the information we requested from the department?
Yeah.
Sure.
Thank you.
So which ones do we have that we have all the information on? Not waiting for anything.
Forgetting 386. Oh, that's your bill on the definitions. Yeah. Yeah. I'm a co-sponsor.
Do we need a motion before I ask a question? Just in the hearing report, Senator kind of talked about, on the last page of the hearing report, you're gonna follow up with the Keene School District? I mean, I support this, but I just, that was one.
Well, I do too. We did reach out to the business officer at SAU 29, and there hasn't been follow-up to that, so I can try one more week.
Which bill are we talking about?
386, this had to do with what's the conversion factor for a part-time enrollment in a block schedule program. Thank you.
So 386, what's the motion?
Madam Chair, I think if we could hold this for a meeting, we can see if there's any further definition we can get.
Okay. You want to hold the rest of them to the a little later date, maybe next time?
I will note, just for clarification, the next time we meet is going to be February 1st, and we will be hearing the 2 large EFA bills. So, not sure how much exacting time there will be, but I just wanted to remind the committee of that.
Thank you. 231, weren't we waiting for some follow-up from Senator Sherman? I don't know if that's,
231, he wants to wait until next week.
he wants to wait in.
Because he was looking for some further information.
That's 21125, which is today. Hang on a second, let's just let me look for anything that's outstanding from earlier.
I'd make a motion to come out of executive session.
Thank you.
Can we get extra time, another 2 hours at some point?
Next Tuesday or generally?
Generally.
I can look into that for the committee to see if we can find an extra block for execing.
Yeah,
Okay.
just for execing.
Yep, I'll look into that for the committee.
Okay. So we can try for next Tuesday, but I'm not sure.
Yeah, that's tough. It's a tough call.
Wait.
Senate Bill 235 is still out. We haven't, I'm correct, we haven't exacted that.
So, yeah, I'm happy to help and go through with this. So 231, it sounds like we're waiting. 235, we have not exec. 236, we exec today. 237 has not been heard yet. 238, we heard today. 351, we have not exec. 353, we just exec today. 381, we just heard today and we have not exec. After discussion during the executive session, it sounds like we want to wait on 386 and we want to wait on 394. 420, we exec today. 426 we heard today, and the remainder of the bills have yet been heard, so that's where we're at.
Well, if we can get 2 hours. Right. So we have a couple of other bills. If we can get like 2 hours at some point.
I will.
That would be great. Then we can just concentrate on, and everybody reads the hearing reports, and if we need to find any information, let's go and find it.
I will look into that.
So we can finish them up. Okay? Is that okay?
It is.
Okay.
Just a heads up on 386 that I'll bring forward an amendment on that addresses a couple of the concerns that came up during the hearing.
Can I have a motion to get out of executive session? Second?
I'll
All those in favor?
Aye.
And that concludes the